Hello, welcome to this. This is April 2024 commercial transaction. My name is James Nginya, founder of Buy Exam Preparation website. This paper was done on 19th April 2024. So this is the latest paper to be done, and we are going to look at it in two series. Today, we are going to tackle question 1, 2, and 3. And on Wednesday, 30th October 2024, we are going to tackle the other three questions, question 4, 5, and 6. So if you want to pass a commercial transaction, it has 8 topics. There is company law, there is insolvency, which deals with the bankruptcy and liquidation, bankruptcy of a natural person and liquidation of a company. There is partnership, general partnership, and LLP, limited liability partnership. There is commercial agreement, where they can ask you to draft any commercial agreement. Any. There is movable property, movable property topic, movable secure property topic. So there is tax procedures in commercial transaction. There is a financial payment system. There is mergers and acquisitions, and it's another topic there. I'm not remembering it. So all these topics, they can ask, they balance all the questions. So like November 2023, it has all the questions from all the topics. And this April 2024, it also has questions from all the topics. So it's very important that you study all the topics. Yeah, and read all the acts of parliament in the various topics and the regulations. Yeah, when you are reading the acts of parliament, look at the process and procedures. Yeah, and also potential forms. Yeah, read all the acts of parliament with a tooth comb. Finer details if you had to pass these exams. Yeah, in all the topics. Practice commercial drafting of any commercial agreements. BRSC website have very good documents. Summarize. It can help you. So subscribe to the Q&A on the website and listen to these videos, because 3 out of 6 questions in any exams are repeated from past papers, directly or indirectly. So the purposes of Q&A, question and answer past papers, is to build your knowledge, to help you to build your knowledge on answering the question that may be repeated directly or indirectly. We also talked about in this video, I also talked about potential areas that can come. So answers must be supported by relevant case law and statutory provisions. As you can see, I'm projecting there. So it's very good to have case law. And if you don't have case law, at least you know the statutory provision. That's why I'm saying you read the acts of parliament and regulations. So we look at question 1, and I'm going to read it. This is April 2024. Question 1A. What I have realized on question 1 of November 2023 and question 1 of April 2024 is that they now are bringing a question which has balancing most of the topics. So question 1 is not about one topic. They bring something in all these topics. Like question 1 is on LLP, B is on financial payment systems, C is on tax procedures, D is on movable properties. Yeah, security rights, movable property. Yeah. So they are balancing on on various topics in commercial. Same thing with November 2023, something that was not being done before, which is a good thing. This is why it is called a compulsory question. So this is now the a good compulsory question. Because why should a compulsory question in one paper be movable properties act, movable securities? The next time is mergers and acquisition. The next is company. The next time is tax procedures. Yeah. So these are good. Is what is called a compulsory question. A compulsory question should balance all the topics. Yeah, if not all, some. So I'm going to read. Vero is an industrial young man from a very young age. Vero has known that her passion was in high-end fashion. As soon as he joined the university, Vero established Waka Company Limited, which she operated for a long time as a sole proprietorship before registering it as one-person private company following the company law reforms that were completed in 2015. Vero is very excited about the industry and hopes to expand her business using new technologies. During her fashion show events, Vero met Tana, a very popular brand ambassador in various social media platforms. Tana has been in the sector for many years and has huge influence on your consumers of fashion. Vero approached Tana to negotiate possibilities of doing business together. The two eventually agreed on establishment a limited liability partnership (LLP) as a preferred mode of business. Both parties agreed that Waka Company Limited should be converted into an LLP so that the business could maintain its continuity. The two parties have approached your law firm to advise them on the information that they should be contained in the statement to be lodged with the register during the process of conversion. Yeah. So the question is very straightforward. So here is conversion of a Waka Company to Waka Company Limited to an LLP, limited liability partnership. What should the statement be? The statement to be lodged with the register contained. So the answer is in the Limited Liability Partnership Act, which I want now to project. That's why I'm saying A good student should read this act very well, and understand the finer details. Yeah. So, conversion of a private company to a limited liability partnership. That is Section 25 of Limited Liability Partnership Act. So a private company may convert itself to a limited liability partnership by satisfying the requirements set out in the third schedule. So the third schedule say, third schedule, third schedule, third schedule, third schedule. So that schedule, welcome Helen. Welcome Helen.
Thank you.
So the third schedule is where the statement to be lodged with the registrar, it has the details, the third schedule of LLP. So statement required to be lodged with the registrar. A company that wishes to convert to a limited liability partnership shall lodge with the registrar statement that complies with subparagraph 2. So what does a subparagraph 2 say? A statement complies with this subparagraph if it is signed by all the shareholders of the company and contains the following: the name and the registration number of the company. So the statement must be signed by all the shareholders of the company. The date at which the company was incorporated under the Companies Act. The name of the proposed liability partnership. The general nature of proposed business of that partnership. The proposed registered office in that partnership. The name and identity document, if any, nationality and usual place of residence of each person who will be partner in that partnership. If any partners referred to F is a body corporate, the name, yeah. So that was the answer. I'm not going to read everything. That was the answer. So the answer was paragraph 3 of that schedule of LLP. Yeah. So uh, so it's good to know the process of conversion of a private company to a limited liability partnership. This is a question that has never been tested. And when I was talking about November 2023 paper, we were discussing, I had not looked at April 2024 paper. And I didn't know that conversion came. So when I talk about prediction, these are very important things, the areas I usually say. So I had not known that conversion came in April 2024. Question 1A. So look at that process. Conversion of a private company to a limited liability partnership. Even the documents. Two conversion that I want students to look at, which has never been tested. Conversion of a private company to a public company, and vice versa. Conversion of a public company to a private company. In fact, anything to do with the public company has never been tested, even nothing, even a single thing. So that is a rich area for testing. Yeah. We are together, Helen?
Yes.
Yeah, I had started before you joined.
It's okay. It's okay.
So, Vero and Tana has decided to operate a payment system that will help business reach the better serve their predominantly online customer located in the vast parts of the country. Write a detailed legal opinion explaining to the two business partners on specific details regarding the application for authorization provision under the National Payment System Act of 2011. So what do you think?
Okay, the paper that I have didn't have question 1, but I'm thinking because these people want to reach the people in remote areas, the best method to use would be they call it the telephonic method, where they use the applications like M-Pesa, Orange Money, because the purpose of such applications was to increase financial inclusion. Because in such places, there are no banks, there are no physical banks. So to allow such people to continue transactions regardless of the absence of physical banks, there had to be an invention of systems that would allow money transfer as long as as long as people have phones. So the such systems would be suitable. Yes.
Yeah. So if you don't have a paper, you tell me to send you,
Okay.
or you look at the website. They are there. Although it is time we are arranging everything. So you prepare adequately. So this question, a good trial. This question, if you are told to write a legal opinion, you write a legal opinion. A legal opinion from legal writing and drafting class. Of course, you know it looks like a letter, but because of 5 marks, you go direct to the point. So, right, I will explain to business person specific details regarding the application for authorization provisions under the National Payment System. So, before you joined, I talked about what I realized about these questions in November 2023 and April 2024 was that these questions, all these questions, wants someone to read with a tooth comp all these acts and regulations and understand them. So the answer is in we can open the National Payment Systems Act. In fact, the question is very direct. That is where you are going to get your answer. So I want to project the National Payment System Act of 2011. And every time you are looking at the Acts of Parliament, download the latest from Kenya Law Report website. In fact, they have a new website which even updates it gives you the latest time the act was updated. So don't use every time you are doing exam, go back to the Kenya Law Report website and download the new acts and Parliament and regulations, because the law keep changing. So For example, the national payment system now that is projecting on your screen is at registration as at 15 September 2023. So this is the latest. Yeah, don't use the old acts. Zile ulidownload kitambo ukaweka pahali or physical copies. Every time you are doing exam, download new acts of parliament and regulation, because the exams, the law is as the time the exam is done. Yeah. And also, yeah. It's good to say that. So, Section 12 National Payment System Act and Section 13 are relevant. No person shall in Kenya conduct a business of payment service except as authorized payment service provider. 12.1. A person who contravenes the provisions Section 1 commits an offense and shall be in conviction liable to fine not exceeding 500,000 shillings of imprisonment for a term not exceeding 3 years or both. Application for authorization. A person proposing to transact the business of payment service shall, before commencing such business, apply to bank for authorization. So the bank here means bank under Banking Act. So they are going to apply. That is the first step, to apply to their relevant bank, the bank that they do where they have opened the business account from. So an application under this section shall be in prescribed form and shall be to the bank together a prescribed fee. In considering the application for authorization, the bank may require to be satisfied the financial condition and history of the applicant and character of its management, the adequacy of capital structure and convenience needs of area to be served, public interest which will be served by granting for authorization. The bank may subject the payment to prescribed fee and such conditions be considered necessary to grant applicant authorization. When authorization has been granted as this section, the bank may add value or substitute condition attached thereto. An authorization issued under this section shall be, unless earlier provoked, be valid for 12 months. So that was the answer, section 13, as read to regulation 4 and 5 of the National Payment Systems Regulation, because the act usually has the application, but an application in prescribed forms, the final details on the forms and the processes are usually in the regulations. So that's why I'm saying someone must read the regulations. I want to project the National Payment System Regulations, the latest, as at that is 1st December 2022, from Kenya Law Report website. So regulation 4 and 5 now has the final details on section 13 of National Payment System. So yeah, let me project. So authorization for payment of a service provided. A person other than the institution defined by her who is to be authorized a payment shall, before commencing business, apply to the bank. So the first step is to apply to their bank. So of course the next the another point, because this is 5 marks, you say the application shall be in the prescribed form. Yeah. And the form they were going to attach, accompanied by the following documents: documents of certificate of incorporation, mobile payments provider, type of services to be offered, information of public interest, a business plan, evidence of payments of everything that is in regulation 4.2, of national payment process. Then a person. So there also it will be accompanied by non-refundable application fee. That is 5.2. So the bank will within the 30 days, 5.3 of receiving the application. Yeah. Consider the request. Yeah. Then the bank 5.5, the bank upon receiving if they are satisfied, they advise them to pay the prescribed authorization fee. Yeah. Then when the bank approves any payment service provided, the bank shall within 7 days issue an authorization certificate to the applicant. So that was the answer to that question. C, 1C, Vero recently received Emmy project. Vero recently received a letter from KRA communicating the fact that she was late in submitting her annual tax returns in relation to Waka Company Limited. In panic, Vero made a frantic call to you seeking your advice on whether she can request the commissioner for an extension of time to submit a tax return under the Tax Procedures 21. Advise her on the steps that can take the request to such extension. What do you think, Helen?
I don't have an answer from the top of my head for this question in particular. I haven't prepared for this one. So you please guide. Yeah. Question C and D. Yeah.
Yeah, because you said you did not get, so we again, these questions I want you to have read. These questions have been picked from the Acts of Parliament, so that is why I am insisting. I said when I was doing the introduction that commercial, you must be able to, you must read all these Act of Parliament and the regulations, the relevant regulations. You can't pass without internalizing the acts and the regulations. And I also say that question 1 is balanced from all the topics. Unlike November 2023 and April 2024, they are balanced the topics in question 1. So question 1 has several topics. Of November 2023 has several topics, and this is also has several topics. So this is where to go. A compulsory question should not have one topic. This time they ask on mergers and acquisition. Next time they ask on companies. The next time they ask on financial payment systems. The next time they act on insolvency. Question 1 should be balanced they should balance various topics, which they have done there. They started in November 2023 and now April 2024. So expect the same in November 2024. So I'm going to project the Tax Procedures Act 2021 because, again, the question is very direct. The answer will come from Tax Procedures Act. You download the latest from Kenya Law Report website. Don't use the old one. A good lawyer should always be updated. Tax things. Usually, every year, the Finance Act, usually, the purpose of the Finance Act is to raise measures for the government, to raise taxes for the government in that year. So they the Finance Act amend various tax laws. So tax laws are amended each and every year. And the capital gain tax, previously it was 5%, now it's 15%. And some of the Q&A I have uploaded on the website. They are talking about 5%, but it is 15%. Those are the earlier one I researched. So take note of that. There's a candidate, a student who told me, you asked me that yesterday. Yeah, so tax area, tax things to do with taxes are amended each and every year. For example, if you look at section 37, repealed by Act Section 4 of 2023. So it was repealed by the 2023. Then repealed by Act. So the Finance Act even is sometimes repealed the some of the section. So the regulation under the Tax Procedure Act, it's good someone to investigate if some are still in use or have been repealed. But the act is there, it's relevant. Yeah, on taxes, you must know that. And you know the courts these days, they have they are into this financing. Finance Act 2022 was Finance Act 2022 was 2024 was nullified, 2023 was nullified. Yeah, so it is good to know which whether the tax law you are reading, whether it has been repealed by parliament or declared unconstitutional by the court. Yeah. So tax laws, that tax procedures, nini topic in commercial. Yeah, that is you must it is a question, or especially on calculations. You must be very updated. So I'm projecting the Tax Procedures Act. So this is on tax return. Yeah. So extension of time to submit a tax return. So a person required to submit a tax return under the tax law may apply inviting the commissioner for extension to submit the return. So what is this application? An application shall be made at least 15 days before the due date in case of monthly return. Yeah, or 30 days before the due date in case of annual return. The commissioner may grant an application under this section if satisfied there is a reasonable cause that shall notify the applicant according at least 5 days before the due date. Provided that where no notification is received under this section, the applicant shall be to have been granted. Only one extension may be granted to the applicant in respect for a tax period. The grant of extension, that is 25(4), the grant of the extension under this section shall not alter the date of payment of any tax due as original due date under the return as specified in the tax law under which the return has been made. The provision of Section 83 relating to penalties last the submission of return shall not apply where an extension to submit a return has been granted. So that was the answer. Section 25 of the Tax Procedures Act. Yeah, first time this kind of question was tested. Other areas on this have been tested. Someone, you look at the Q&A, which is uploaded on the website. So I go to the next question. Vero and Tana are very ambitious partners. They have identified a prime location in the middle of CBD to launch their operations. The two have decided to jointly take out a mortgage using their logbooks and other movable property that they own. Explain the two partners the obligation that may be secured and asset that may be encumbered. So this is now this is on movable property security rights topic. This is not a very hard topic. is a question you can answer well if in an exam. Yeah, if you understand the acts and the regulations, and there are some documents, the MPSR manual at BRS website is very good. It summarizes this topic. I would encourage everyone to look at it. So the answer to this was found in section 7. Again, these are questions which have been picked directly from the Act. Directly from the Act. Movable Security Rights Act. You download the latest from Kenya Law Report website. Don't use the old acts. The latest is the legislation at December 2022. Yeah, so the answer is in section 7. Read, make notes on Movable Property Security Rights Act and its regulation. A question will come there directly. Yeah. Unless, of course, the BRS process, you need to know the forms and the processes, and maybe to draft, maybe security rights, which have already been asked. So most of the time, most likely the question will come directly from the act and the regulation. So obligation that may be secured and asset that may be encumbered. So section 7 on your screen, a security right may secure on one of the more obligation of any type, present or future, determined or determinable, conditional and conditional, fixed or fluctuating. A security right may encumber any type of movable assets, whether chargeable and dischargeable, parts of assets that are undivided rights in movable assets, generic categories in movable properties, and all of grantor's movable assets. So that was the answer. Pick directly from section 7 of the Movable Property Security Rights Act. Yeah. So I'll go to the next question. That is question 2. And I'm going to read now. Question 2, April 2024. Zacchaeus is a well-known South African millionaire who has let me project. Zaka is a well-known South African millionaire who has made his wealth in the fast food business by selling Tanchi Crunch chicken through the outlet in South Africa known as BFC Chicken. He inherited the business from his father, and the reason for the success of his business has been secret recipe of the crunchy chicken. This is a recipe of well-guarded family secret, and over the years, the family has ensured that only members of the immediate family have access to the recipe. In fact, all the branches in South Africa are headed by family members who have the only ones who have access to the recipe. Unfortunately, Zacchaeus and his immediate relatives are well known over 70 years and are considering retiring from business soon, at least in active sense. He may have grandchildren who eventually take over, but the time being still very quite young. Zacchaeus visited Kenya in June 2020 and was impressed by the vibrancy of Nairobi and the touristy nature of Mombasa, as well as the level of business growth and population. He is on the opinion that despite the existence of KFC and Burger King, he sees a great opportunity to expand his business and expand his income for his grandchildren. He has decided to visit your distinguished law firm, which specializes in commercial law, with a view of exploring business format options available to him. He has provided you with the following information. He is not interested in engaging directly in expanded business, but wants to regain a great measure of control over how the business is to be conducted. He will play a key role in determining who will be the manager of the business of the outlets. He does not want to invest any money in the business, but is looking for someone who can invest assets and resources into the business in both Nairobi and Mombasa. We are able to share in profits by way of engage some. He will not allow use of his business format. He will allow the use of his business format, brand name and image, and those who could be retained as they are. He reveal the business, his recipe, and other business information and the knowledge, but these secrets should be strictly protected. Yeah. Advise suckers on the most appropriate business format. That is 2A. Helen, 1 mark.
A franchise.
Yes, a franchise. So, saying a franchise is not enough. You define what is a franchise. Eh?
Okay. Let me try and define it.
Okay.
So a franchise is where a business owner lends his name, the name, the brand, and business strategy or manner of operations to another business to carry on operations as a branch of that main business. Yes.
Yeah. And you must use the word franchisor and franchisee. So Zaka is a franchisor, and what are they called? Yeah, the people he's going to work with in Kenya are the franchisee. Eh? So the next question, you define what a franchise is. The next question, business format, a 1 mark. So you say it and you define, and you get to a marker. Explain clearly what such a commercial concept would entail, its suitability, and the entire scope of legal and other considerations that would have to be reflected in such an arrangement and nature of agreement to be signed. That is 2B, Helen.
So let me start with the nature of the agreement will be a franchise agreement. So this kind of operations, as I said, will have to do with the franchisor lending the name, the brand, and manner of operation to the franchisee. So how it will operate is that the franchisor will not participate directly in the management of the franchise, but he may participate in the selection of a manager. However, he will not participate directly. With the franchise, it will help the franchisor not to start a business from scratch. It will not be he will take advantage of what the franchisee already has retained in terms of market. So he will be able to take advantage of that market. He will not be starting from the ground. Also, matters recruitment and dismissal of employees will not be within will be left to the franchisee or the management of the franchisee. Also, the franchisee will have to operate exactly the way the franchisor usually operates. Because, for example, this kind of business, they intend to retain the quality of services or goods they're providing. So there's going to be training or the exposure of a secret, whatever they do, to produce a certain quality of goods and services, they will have to train the franchisee on how to produce similar quality of goods and services. Also consideration, the suitability, also because it is suitable for the franchisor, also because it allows the franchisor to explore international markets. Since the business was only based in South Africa, once the franchisee somehow wears this new outfit, it enables the franchisor to reach out to a new market. Therefore, expansion, increase in profit. Yes.
Yeah. So, yeah, that is a good answer. Yeah, I don't need to add so much on that. That area, you know. So highlight 4 clauses that should be in the agreement in B above. Yeah. 2C.
Clauses. I believe the names of the parties, the name of the parties being involved, the nature of the business being carried out, the profit sharing arrangement, termination, or when the franchise commences, there should be a clause termination of the agreement. Yeah, I guess I can remember those 4.
Yeah, so also to add, of course, parties, you cannot forget termination. Territorial rights, the geographical area where a franchisee can operate and develop franchise business. Minimum performance standard, the franchisor requirement of franchisee for benchmark sales, revenue, or other metric. Yeah. Franchisee payments, very, very important. These are royalty payments a franchisee must make to the franchisor, typically a percentage of the net revenue. Trademark use, the license obtained by franchisee to use the franchisor brand and other marks to promote its business. Yeah, they must talk about the trademark. Advertising standards. There's basically advertisement requirement for franchisee when promoting the franchisor products. Exclusivity clause. The right of franchisee to sell or distribute the franchisor's products within a given territory. Yeah. Insurance requirement. The obligation of the franchisee to insure against business losses and other liabilities. Yeah, so those are some of the on some of the clauses. One needs to Nini. So this question should not be, of course, drafting a franchisee agreement. Has not been tested, so that can come. These are they are acting only using here is the clauses. So franchisee and distributorship should not be confused. So one must be able to differentiate in an exam a question between distributorship, which has been tested in the past, and franchise. So how would you differentiate it? The exam between distributorship and franchise? Helen. Helen, are you there?
Sorry, I had dropped. Nimerudi sahi. Ilikuwa ime drop kidogo.
I'm saying
Yes.
a distributorship and franchise come together hand in hand.
Of
So how would you, in an exam, know that they're asking you this is franchise and this is a
Okay.
distributorship? Yeah.
So for unlike a franchise,
Mm.
a distributorship usually the distributor the distributor will operate in his own name. There won't be an adoption of the name of wherever he has bought the goods from. In fact, for a distributor, he will buy the good in his own name. Unlike a franchise, where the franchisee will wear will adopt the name of the franchisor.
Yeah.
It's like he will be wearing the outfit of the franchisor.
Yeah.
Sometimes
So that is the difference.
a distributorship.
So so you are not very clear. But yeah, your audio is not good, but I have gotten your point. So in an exam, it's good to know the difference between franchise and distributorship. And distributorship have been tested, even drafting an agreement. Yeah. So it's good. This is drafting of commercial agreements topic, which has these two things. Yeah, we got to the last question of the day, which is question question 3. Yeah. Hot Wheels Limited, the largest used car trader by market cap in Kenya, has resolved to purchase all the assets of one of its competitors, Automat Limited. Automat is a local subsidiary of conglomerate known as Tajiri Holdings and is operated independently from its parent company. An assignment and transfer agreement for acquisition of all the motor vehicles and intellectual property rights that are associated with Automat Limited has been signed by parties. Of the agreed purchase price of 500 million Kenya shillings has been paid to Automat Limited. The Competition Authority of Kenya has now returned to Hot Wheels, inquiring on the nature of transaction and why they are not notified. In response, the acquirer and the target company sees the acquirer has merely acquired the assets of the target company and had said the company will continue as a going concern. As counsel for CA, Competition Authority, briefly explain to your boss how you intend to make a case against concerned undertaking in support of the finding of the anti-competitive behavior by parties and the penalties that may be levied. Yeah, interpret the question, Helen.
In this question, there is a used car retailer company.
Mm-hmm. Mm-hmm.
$500 million
Mhm.
And
I can't get you. Mhm.
apparently they've not been notified. Right now, can you hear
Mhm.
me? Can you hear me now?
Yeah, I can hear you. Yes.
The competition authority, okay. The competition authority has not been notified, and Hot Wheels Limited does not see the need to notify the problem in not notifying the competition authority.
Mhm.
In a way, it seems that it does not understand that what it has done is
Mhm.
worthy of that kind of notification.
Mhm.
Yes.
Yeah. So, what is the answer now?
I think it is a merger, because a merger involves the acquiring company taking on the assets and the liabilities of the target company. It just takes on everything that has to do with that company.
Mhm.
Yes. Or do I answer question 1 as it is? The question A.
Yeah. You answer question A.
So I would, as counsel for the competition authority, first of all, the Hot Wheels Limited does not realize that what it has done, the acquisition of assets in itself, amounts to a merger. And the mergers fall under the supervision of the competition authority. So after that,
Mhm.
the amount of money spent in this merger
Mhm.
falls under the category of notifiable mergers.
Mhm.
So notifiable mergers, one of the notifiable mergers are those that where the
Mhm.
assets of the company are between 500
Mhm.
million, and I think you can correct me there, between 500 million and 1 billion. So anything above 500 million has to be brought to the
Mhm.
attention of the competition authority.
Penalties, the penalties that will be levied.
I think I have.
Mhm.
I don't know about the penalties. I
Okay.
don't know about the
Good
penalties.
trial.
But the anti-competitive behavior is not notifying the competition authority.
Yes, good trial. On top of that, I will add you more points. So this question
Okay.
again wants you to understand what are the instances where a company needs to notify the CA, the competition authority. Which are the, on top of the amounts involved, which are the other factors or other criteria? So this is another question that needs someone to understand the competition authority, the competition act. So I'm going to project the competition act. You go to the Kenya Rule website, you download the latest. So the latest competition act also from that as at that 1st December 2022, which I want now to project. Yeah, so The relevant section is section that one. And section 36. So we are going to start with section 31. The question was is how many marks? On top of the amounts which are involved. Question 4, yeah, you yeah, on top of the amounts. So the authority may on its own initiative and upon receipt of information or complaint from any person carry out investigation, conduct or proposed conduct which alleged to constitute an infringement of. So you are concerned it's a part of finding of anti-competitive behavior. What are the uncompetitive behavior by the parties? So prohibits related to restrictive trade practices. So that prohibition related to abuse of dominance. Prohibition related to abuse of buyer power. So anti-competitive practices must follow on these three. It may either prohibitive of restrictive trade practices, prohibition of abuse of dominance, and prohibition related to abuse of buyer power. So we need to know what is restrictive trade practices. Restrictive trade practices. What are the restrictive trade practices? That is now section 21. Yeah. Agreement between undertaking decision by association or undertaking of the decision. 21.1. By undertaking or consult practices by undertaking which have their object or effect the prevention, distorting, or lessening of a competition in trade in illegal goods in Kenya or part of Kenya. Yeah, remember this company, we are told that Hot Wheels, the largest used car retailer by market cap, have resolved to purchase all the assets of its competitors. So that is where the cruise of the question is. So the largest company in car retail company resolved to buy the assets of one of its competitors. So this is a restricted trade practice because it is trying to lessen competition. When you buy, so 21.2 agreement, decision on concerted practices contemplated in now include agreements concluded between parties, horizontal relation being undertaken in trading in competition. So horizontal, these company are in competition with each other, but Hot Wheels has decided to buy one of it. So that is a restricted trade practices. So you start with section 31, and then you come the definition of restrictive trade practice. Section 21. Then there is dominance. What abuse of dominant possession. Yeah. So what's the meaning? One of the section 36, section 31. We have said it is 3 things: prohibit a restrictive trade practice, abuse of dominance, and abuse of buyer power. So what is dominance? Is we now look at the definition of dominance. How do you define that a company is dominant? So dominant is defined in section 4. Yeah. Abuse of dominant position, section 23. For purposes of this section, dominant undertaking means taking which produces, supply, distributes or not less than one of the total of the execution produce distribute in Kenya, provides otherwise control of not less than half. So abuse of dominant position, section 24. Any conduct which amount to abuse of dominant position in market in Kenya or substantial without prejudice to generality. Abuse of dominant position includes directly or indirectly imposing unfair purchase or selling prices to unfair trading. Yeah. So it is the abuse of dominant position of Hot Wheels and engaging in restrictive trade practices. Yeah, you quote those sections. And also the amounts. We got to the last question of the day. All other factors, 3B, all other factors remaining constant. Hot Wheels has insisted and instead opted to buy the controlling number of shares in auto market rather than buying out its assets, and will also wield the power to appoint or veto a majority of directors. Analyze whether or not the proposed transaction satisfies the derivation of the time merger and the criteria spells out in law for a party to be considered in control of an undertaking. Helen?
Please project the question. I'd like to see it again.
So all factors remaining constant. Hot Wheels Limited and instead opted to buy a controlling number of shares in auto market rather than buying out its assets, and will also use the power to appoint or veto majority of directors. Analyze whether or not the proposed transaction satisfy the definition of the term merger and the criteria spelled out in law for a party to be considered in control.
I think here buying a controlling number of shares indicates a takeover now. So this will be a takeover, and for takeovers we use acquiring company and target company still.
Yes.
So where the acquiring company acquires as the question states, a controlling number of shares or a sufficient number of shares to take over the control of the market.